All right, I think we're doing enough time to trickle in. Good morning, everyone. Good morning, everyone. No need for it. No need for clapping. It's Wednesday. We love Wednesdays. It is Wednesday, right? Yeah. We love Wednesdays because we get to do civil procedure now. Civil procedure, everything you learned, like this message, civil procedures should be helping you make sense out of these kinds of headlines. Right? You understand the world so much better. Isn't your life so much richer for having a civil procedure get better?
I wanted to show that I attempted to explain the eerie doctrine to a layperson when they visited me this weekend. She is now in the that we are all certifiably insane.
Yeah, no, I don't want to do that. I don't want to do that. This is not to alienate lawyers from the rest of society. Having to get into the nuts and bolts of the eerie doctrine, we'll talk more about that in a little bit. The Covington Catholic lawsuit, there's another Covington Catholic lawsuit that involves Senator Elizabeth Warren, who I represent, so that's not the one we're talking about here. This was the one that was filed, the first one, the main one, last year. $250 million. If you were reminding me last we did a mock mediation over this. It was dismissed, right, by a federal judge, and now this headline tells you that it's been reinstated. Does anybody want to hazard a guess on what procedurally happened here?
The eerie doctrine.
The eerie doctrine, absolutely. That's nothing to do with it. Nothing has anything to do with the eerie doctrine.
Appeal and dismissal.
You can appeal and dismissal. This is not, so that's the thing that you want to be thinking, right? You want to think that, all right, the case got dismissed. How do you think it got dismissed? Let's deal with that first.
Summary.
12B6. Or summary judgment. Right? I believe this one was in fact 12B6. Okay? We haven't had time for it to appeals court and come back now. Okay? So how does it get reinstated? The judge says, yeah, I don't think this is defamation, so defendant, you're right, Washington Post, you're right, you win. You dismiss all the claims. No more lawsuit. You're the defendant, what do you do? What do you think? Yeah.
How long does it reinstate?
We're all probably wrong all the time.
I was thinking if they did dismiss it, I mean, they just gave them an opportunity to address the issue. I would just approach it.
Well, what do you mean by give them an opportunity to address the issue? What do you mean by that?
They always wait.
Well, the case has been dismissed.
I know it's dismissed, but it's just.
Did you not get an opportunity to?
The case is dismissed under 12B6 law. The question is, I mean, you got to think the right way. The question is, how do you take that opportunity? The court's not going to say, hey, why don't you file an amended complaint here, and why don't you file this other motion, why don't you do this other stuff? How do you do that? What procedure is it? Okay.
File a motion.
File a motion for what?
When did you do it?
File a motion to file an amended complaint? Okay, the case has been dismissed.
Before. I'm saying before the dismissal.
Before it was dismissed? Yeah, that would have been good. The case already dismissed. The judge dismisses the case. So my question to you is, you got your defense hat on. Your case has been dismissed. What do you do?
You file a motion after, right?
You can.
And then if they deny the motions, then they can appeal it?
Yes. This never makes its way to the appeal court. My question is, what's the motion that you file? Right,
Motion to reconsider.
Motion to reconsider. Motion to reconsider. Similar to you think, right? Similar to you think. This is the problem. We get to this point in the semester, you start thinking about the eerie doctrine and claim preclusion and all this stuff. Like, my God, what's this tangle of confusing rules that I have to know to be able to get this undone? You just file a motion to reconsider. In fact, that's what happened. They filed motions under Rules 59 and Rule 60. It doesn't really matter because the court has inherent authority to reconsider these things. Any court does, right? The defendant files a motion that says, no, wait a minute, you got this all wrong. Here's why you got it all wrong, and we'd also like to file an amended complaint separately. So what happened was, this same federal judge reversed himself on a motion to reconsider. It doesn't happen very often, but it does happen. Reversed himself and reinstated 3 of the 33 claims or whatever. Reinstates 3 of those claims and says, you know, I don't really think, says essentially in this 5-page order, I don't really think very much of these claims. But justice demands, this is actually what he says, justice demands that you get to conduct discovery, because they have to do with state of mind type stuff. So they get to take discovery on those 3 things. And the judge is essentially saying, all right, you know, we're going to revisit this on a motion for summary judgment. Make sense? Is that fine? Does this help you understand the world? Well, let's talk about Erie some more. Because it's confusing. There's some first-year professors that, I guess you guys technically second year, some first-year civil procedure professors, even here at this institution that don't teach Erie at all. I was kind of tempted at the beginning when I was doing my solo design course to go that direction because you just don't run into these problems that much when you're actually in practice. You do have to have it for the bar too. Okay? So if you get an exam question in here, or I think a work of the bar, you really want to get down into the weeds of Erie, you need to take Professor Cross's advanced civil procedure. And I think it might be a good idea for you to do that anyway, because many of you, if you end up in civil litigation, you know, you're either going to end up, most of you, in civil litigation in some capacity, or doing transactional work in some capacity, or both, right? And the procedural stuff, being able to sort of parse out these procedural problems, is helpful for both those things. Now, if you go to work for a public defender, none of this will mean anything to you. But here's the stuff that you really need to understand, for me, and I think for the bar. The big distinction is make sure that you understand the difference between substantive and procedural law. And for probably about half of you, you're sitting there going, yeah, of course I understand the difference between substantive and procedural law. And the other half are going, yeah, I'm still a little fuzzy on what substantive and procedural law are. Maybe all of you are a little bit. And that's okay. Just know that if you're a little fuzzy on what the difference between substantive and procedural law even is at this point in your legal career, that's okay. You're in good company. The federal courts, and this is the thing Professor Cross was talking about here, federal courts don't get to make state law. Right? Federal courts really don't get to make substantive law at all. Congress can, but the federal courts can't. They can make procedural law for themselves. can't make substantive law on torts or contracts or anything else like that. So most of what we're talking about with Erie problem type stuff is going to be common law oriented, federal common law oriented. If we're talking about a federal statute, it's probably not an Erie problem at all. If you have a federal statute that governs a cause of action, I've talked to you a couple times about 42 U.S.C. 1983. Don't get confused about the distinction between federal statutes and federal rules of procedure and then state substantive law over here. If you have an action that's based on original jurisdiction, when I filed a case based on 1983 or any other federal statute, this stuff doesn't even come into play. And there's really an extremely narrow subset of cases where you have to worry about Erie at all. It's only where you have some kind of conflict between federal and state law. You know that the federal courts have to apply state law on a substantive issue and federal law on a procedural issue. You're probably going to be okay. Yeah.
So, that video you posted,
That video will take you more time than the weeks than probably for this one. Go ahead.
well, so, she had a chart in there, you know what I'm talking about? She went over the choice of law one.
Mm-hmm.
Is that?
We'll get there. We'll get there.
Okay, so that doesn't come on this.
It does.
Right. Like not yet.
Now, well, the choice of law stuff is practical stuff that I think that you should know. We're getting there. Okay?
But it's not like the same thing as the procedural successive thing?
It is. It is. It's sort of, it's tangled up in all that. We'll put it that way. We'll get there. It's confusing. So if the question is whether or not somebody wins on the merits, do they win their case? Was there negligence? Was this a breach of contract? Was this a battery? You're going to have to use state law to make those determinations. If it's procedural stuff, how do we file? How many times can we file? What's the filing fee? In fact, what's the statute of limitations? Which is one that confuses everybody. Okay. Probably going to be federal. Little asterisks by all of this because there's exceptions to everything. The exceptions are numerous and they're complicated and they're really tempting for legal academics to try to pull you down into trying to get into all the thorns and brambles of Erie. But I think that tends to make you want to overcomplicate these problems. And these problems ultimately, if you see a question like this on the exam, I will set aside this, we'll talk about it. But I can repeat it a couple times. If you see a question like this on an exam, there's going to be one party that is asking for federal law to apply, there's going to be another party that wants state law to apply. And what you'll have to figure out is whether or not the law that each party is trying to apply is substantive or procedural. That's what you have to parse out on an exam question. Right? How do you parse that out? Well, there's a million different ways. Right? Does this lead to forum shopping? Is it arguably procedural, et cetera, et cetera? But you have to first decide if there's conflict at all, then decide if it's substantive or procedural. That's the basics of the thing. Okay? So talk more. You don't happen very often in your life, then why not? What are the kind of cases that we're normally litigating in federal court? Well, as I've said, anything that's based on original jurisdiction, anything that's based on a federal statute, 1983 actions, bankruptcy actions. Right? If there's something, some federal FMLA, some federal cause of action that's allowed me to be in court in the first place, I mean, that's allowed what we litigate in federal court, and there is no Erie problem with those cases. Unless you have a supplemental claim, unless you have supplemental jurisdiction over some state claims. But even then, usually we know what we're talking about, right? So if I file a case in the Western District of Kentucky that's based on Title VII, Civil Rights Act of 1964, the Federal Act, it's employment discrimination, and I decide, well, I'm going to lump some state torts in there too. There's usually not a dispute over what state law controls those torts, right? Usually bring in under Kentucky law, and if I'm not, I'll say so. So you're usually not fighting about that kind of thing very much. Now, choice of law provisions are a different thing. Choice of law provisions you do see come up a lot, especially if you're doing transactional stuff. Because, as in the article I sent you guys this morning, you see contract lawyers, transactional lawyers, putting in these clever choice of law provisions into everything that they draft. Right? Let's go back and get more basic. I think one of the things that throws a spanner in the works about Erie from the word go is the simple fact that you all don't really think about the fact that any court can apply any law from any state at any time. Okay? That sort of seems counterintuitive, right? If I file an action in Kentucky, in a Kentucky state court, in front of McKay Chauvin down the street here, and McKay looks at the case and says, oh my gosh, I think Tennessee law ought to apply here. He can apply Tennessee law. There's nothing in the world that stops him from doing that, and sometimes he has to.
In that article you shared, I mean, I get what they did, but I didn't maybe understand why they did it.
Yeah, we'll get it. Yeah, we'll talk about that.
Well, okay, never mind, I got it.
The choice of law.
Because it wasn't as
Now, here's the thing that is also a little counterintuitive. When you're deciding what state's law applies, that decision is itself substantive law. Okay? Does that make sense? It'll make sense after we work through that first problem. Yeah. When you're trying to figure out what state's law applies in any given situation, the choice of law rules, that's substantive law. Okay? So if I'm researching a situation to try to figure out what state's law is going to apply, right? I have to research the law of the forum state. In other words, the law from where the action is applied. So I file an action in the Western District of Kentucky. And here I am in the Western District of Kentucky, and I'm going to look at Kentucky law to determine what choice of law provisions to apply to this case. Okay? So I filed an action in the Western District of Kentucky. The other side says, all right, well, this auto accident, or whatever it was, happened in Tennessee. So we should be applying Tennessee law. And I said, no, my client lives in Kentucky, so I want to apply Kentucky law. To determine what law to use, we look at Kentucky law, right? And that's substantive law. And we look at the choice of law provision, we do the research on choice of law provisions and how to make the decision as to what state's law applies. You do that research in Kentucky. Is everybody with me? Okay. The forum state governs choice of law provisions. The forum state governs choice of law provisions. Choice of law provisions are substantive law, not procedural law. What is that research going to look like? Well, usually, right, in my hypothetical, I do my research, I look at Kentucky law. Kentucky law says you apply the law of the state that has the greatest interest in the outcome of litigation. That's pretty much what it says in every state. Well, what does that mean? You have to do your research and figure out what that means. It's beyond scope of what we're talking about. The point is, if you will be researching in Kentucky, what state's law applies, okay, to this particular situation? If that question even comes up, which very often it does not, but sometimes it will. So, for example, what happened here in this article? The clever drafters of this contract
All right. Thank you.
specifically said this contract is governed by New York law. Is that something you can do when you draft a contract? Oh yeah. Yeah. But the parameters of just how much you can do it are governed by the forum state. And so wherever the action is filed, that's the hitch. So I draft a contract that says this whole thing is going to be governed by the laws of New York. An action for which contract is filed in Delaware. Delaware says that's fine. We'll apply New York law here. But you didn't say specifically, we're only going to apply substantive New York law. You didn't say specifically that the New York statute of limitations was going to apply. Right? And that's procedural law. Since that's Delaware procedural law, we're only going to give you a 3-year statute of limitations. Sorry. Right? Allison.
This might be kind of like a side question, but I read an article recently that there was a judge who actually extended the statute of limitations instead of in the interest of justice and fair play or something like that. So arguably, like this whole piece is based on statute of limitations, and the judge had just been like, I'm going to extend it in the interest of fair play. But, you know.
Judge could have applied New York law. Could have. Yeah.
But is that something that happens where the judge will extend statute of limitations?
No. No, don't count on that.
Okay. But so it's
Don't count on that. I mean, as you said, it can happen. Anything can happen, right? But I think that's an anomaly, right? For a judge to say, well, but I think probably what you're talking about is a tolling of statute of limitations. And in most jurisdictions, there's a doctrine of equitable tolling that you can argue to the judge, like, look, because like the discovery rule, if you talk about that in torts, that's kind of a species of equitable tolling. So I had a doctor that left a sponge in me during surgery in 1984, but I didn't discover it until 2017. And so when does my statute of limitations start to run on that? Well, technically, it would have started to run in 1984, but because of equitable tolling, right? Huh? The discovery rule, right? The discovery rule tolls that statute of limitations. When we say tolls that statute of limitations, it extends it out. Right? And there's several different reasons why a statute of limitations would toll. But in this case, they probably made the tolling argument.
Okay.
But the judge said, no, I don't want to do that. Right? And that's something that would be soundly within the discretion of the court. Okay? What's happened here is that the Delaware court, so this actually got filed in Delaware. Okay? And the Delaware court says, we'll apply New York law, that's fine, but this contract doesn't specify substantive versus procedural. And it doesn't specify a statute of limitations. And so we're going to apply Delaware procedural law. Yeah, go ahead.
This is in Delaware federal court, not federal statute of limitations.
State court.
I mean, hypothetically.
Oh. If it was filed in a, yeah, we would use the Delaware statute of limitations. Asterisk. Problem. Who knows? It's a wild west. Everybody kind of see how this works? Let's do this first problem. I'll talk you through it, okay? If you haven't read it, take a minute to read it. Next week's one. It's a new problem. Car accident that happens in Florida. Defendant lives in Michigan. Plaintiff says, well, the hell with it. We want to avoid. Yeah, go ahead.
Oh, sorry. I was going to say yes. Let's find out.
Let me talk to you. I appreciate your zeal. Accident happens in Florida. Plaintiff says, too complicated to litigate this thing in Florida. Just going to file suit. Where does the defendant live? Is that a realistic situation? Sure. Now, just because the action is filed in Michigan, that doesn't mean that Michigan state law applies. In fact, that's the focal point of the dispute, likely to be the focal point of the dispute between the two parties in this case. One party says, I want Michigan substantive law of the state of Michigan to apply. The other party says, I want the substantive law of the state of Florida to apply. Just as an aside, no one is saying, I want the substantive law of the federal courts to apply on negligence in an auto accident, because there is no such thing. So litigants here have a choice. We can apply Michigan law or we can apply Florida law. How do we determine which one applies? You research. Research Michigan law. Right? That's the forum state. That's where it's filed. So you research what law applies, the choice of law provisions, stuff in Michigan, state law. Okay. Don't have this information in the problem. Assume the Michigan's choice of law rules say that negligence is governed by the state of the law that the occurred in. In other words, Michigan's choice of law, you get into researching Michigan law, and Michigan says Florida law applies. So then whether or not the defendant was negligent, that ultimate question, the question on the merits, is going to be determined by Florida law. Okay? Is there any more that I need to go?
Does that mean that, let's say that conclusion that Florida law applies, does that mean that the court in Michigan has to transfer back to
No.
it doesn't?
No, that's a good question. No, it stays in Michigan. Right? As far as we know, it stays in Michigan. Now, you can make your motion to transfer, you can make a motion for foreign nonconvenience, you can make a motion to transfer venue. Okay? But Michigan procedural law is still going to apply, right? Procedural law of the federal courts, and more specifically, of this district in Michigan. I don't know what to tell you this. Western District of Michigan. That's the procedural law. Okay? The dispute here is over negligence. Whose cases on negligence are we going to be reading to determine who's at fault here? Florida's cases. Right? Whose cases on whether or not an amended complaint relates back are we going to be reading when we look at this? Michigan State or federal?
So,
Federal because, and don't get too lost in this stuff, right? If it's procedural, it's federal. Right? These are your questions. If it's a procedural question at all, federal law does. If you can carve your way through this first problem, this is really what you need out of the Erie Doctrine for purposes of this class. Okay? Yeah.
I did, since you gave us like to assume something about Michigan law,
Yeah.
like if they wouldn't have said that, like how are we supposed to get that?
I don't know. I have a teacher. So, no, basically, what the problem wants you to say is that the forum states law, the law of the forum states, not federal, governs the choice of law, right? And whatever that forum states law says. Yeah, I'm giving you extra here because it makes the problem make more sense, right? But the problem doesn't say. What the problem wants you to come up with is Michigan state law will tell you what choice of law, what state's law is actually going to govern the torts. Okay? So you have an interplay here of three different sets of laws. Sarah?
So it's been confusing to me that we learned last year in civil procedure that when you file and if you file in jurisdiction and consent, but does that just mean you consent to jurisdiction and there's still choice of law rules you can't consent to?
You can. I mean, the parties can consent to have the thing. I mean, if the two parties agree that Michigan law should control the case, judge is probably going to.
If you're just consent to jurisdiction, so that's why we still use choice of law.
Yes. Yeah.
Can you say that again?
Yeah. I'll try.
You don't have to do that.
No, it's okay. Like, the idea here is if everybody consents to jurisdiction in Michigan, it kind of goes back to what was asked before. You know, you could move this to a different court. We're assuming for purposes of this problem that it doesn't get. Okay? That everybody wants to stay in Michigan. But that doesn't mean that we apply exclusively Michigan law. As we've seen here, you apply federal law to all the procedural stuff because you're in federal court. Right? You're in federal court. Federal procedural rules govern. You apply the substantive law of the state of Michigan to determine whose law controls the outcome, the ultimate outcome of whether or not there was negligence. And you apply Florida law. Because of the research you did in Michigan, you learned that you need to apply Florida law to determine who is ultimately negligent. Are you with me? Kind of? Good. Let's do some more. It's already taken 45 minutes. We haven't even gotten to claim. Is this fun? We would know this. The federal rules of civil procedure, all that federal procedural law, again, very repeating. You don't just toss out all the federal law here. Okay? Procedural stuff still applies in the problem that we just went over. You don't revert to using the Florida rules of civil procedure, or even the Michigan rules of civil procedure. You use the federal rules of civil procedure still. Okay? So don't be tempted to throw the baby out with the bathwater on these very type of questions. Procedural stuff is federal. Substantive stuff is state. If you can keep those two boxes separate in your brain, you'll be fine on the exam. Okay? Two. Citation. This is a filing fee question. Yes, please.
Okay, let's
I'm just reading it for the first time.
All right. So, civil procedural, the filing, the federal court filing fee applies, and so motion denied.
Simple as that. Simple as that. Is there any universe in which a filing fee can be substantive law? I mean, you can make that argument. If you see it come up on an exam, make the counter argument. Why not?
Is that something
Let
Congress
me know.
could-
Come on. Huh?
Is that something where like if Congress had come in and said in these types of cases, blah, blah, blah.
Yes, but I mean, I still don't think that takes it out of the realm of procedural law. Okay? It doesn't remove it from the realm of procedure. So even if it's this dramatic difference between whatever the hypothetical is, you know, $20,000 versus $100, it's still procedure. Federal law still governs. In fact, as I read your hypothetical like that, you have a defendant that's saying, you're in federal court, think about this. You're in federal court, you're litigating in federal court. And the defendant files a motion to dismiss saying, you should have paid the filing fee that's prescribed in the state court, that's ridiculous. That's sanctionable, that motion. Okay? You think about it in those terms, I don't know, maybe we're not there yet, but if you think about it in those terms, it's obviously procedural. The defendant obviously loses that motion. That's an easier one in my way of thinking, Carter, than the first one. But it's less realistic, right? The first problem is the kind of thing you might actually litigate someday. In fact, I have litigated something similar to that in a car wreck case. Being this close to Indiana, and if you know anything about who works at a personal injury firm or has worked at a personal injury firm, who knows anything about the difference between auto accident litigation in Indiana versus Kentucky? It is a different universe. It is a different universe in terms of the damages that are available to you. And so you run into questions of which state's law ought to apply in car wreck cases as between Kentucky and Indiana. Yes, for sure. All right. Number, well, no, let's not go to number 3. Okay, let's go to so that's something. All right. Breach of contract. Case sits there for years. Normally under these circumstances, by the way, a court will dismiss the case to respond. But for some reason that hasn't happened here. So a motion is filed to dismiss the to prosecute. And then 41B, the dismissals are with prejudice. No, with prejudice means you don't get to refile. It's never coming back ever again. You lose forever. Is that an adjudication on the merits of the claims? Let's stop there and think about that because it's pertinent to what we're going to talk about in claim. This dismissal for failure to prosecute an action, is that a dismissal on the merits? Even though you can never ever bring it back ever again. Not really. The court hasn't decided the merits of the case. They're just saying you can't file it again. For whatever reason, you can't file it again. That's what a dismissal with prejudice means. It means you lose forever. You lost your only opportunity to bring this to a case, to the court. You don't get it anymore. But that is not dismissal on the merits, nor is it substantive at all. It's procedural. Right? It's inherently procedural. First, in a problem like this, you would ask, is there even a conflict? Think about it. 41B says dismissals are with prejudice unless the court says otherwise. The state rule in this problem, I believe, says that dismissals are to be without prejudice unless the court says otherwise. But if the court applies 41B, they're saying otherwise. Is that really a conflict in the first place? Not if you're trying to avoid conflict. Right? Which you're supposed to do in your hearing analysis. You're supposed to try to avoid conflicts between federal and state law where possible. Here, it's possible. So if this question comes up on exam, first we analyze, is there a conflict? Probably not. But even if there is, this law is inherently procedural, you apply the federal rule. Yeah.
So we're in federal court, District of Superior, I'm confused by that.
Because it's a fantasy jurisdiction. But
District of Superior.
yeah, no, it's
okay,
I don't know. That kind of thing, as you know, that kind of thing, as you know from last year, that kind of thing doesn't not but it's so, it's so obnoxiously fastidious students don't go looking up the state law and say, well, that's not exactly what happens here. We're just talking about this hypothetical. We understand why it's done. Say it's Kentucky. Right? Every place you see the word superior, replace Kentucky. So the same thing applies, right? Works the same. The problem is a lot of these hearing hypotheticals are so far-fetched. I mean, you end up with $20,000 filing fees and stuff like that. And all of them that I've looked at over the last few weeks are kind of like that. I'd rather use something and if I were to give you something on an exam, it would probably be something like this first problem. It really is an honest to God kind of situation that you might face in real life practice. That's not to say that's what you're going to get from the bar exam. Questions about those problems? To recognize these things on an exam. You're going to have in federal district court. There's going to be diversity jurisdiction or supplemental jurisdiction over state law claim, most likely, in the hypothetical. Because if we're talking about original jurisdiction, we really don't have any problem at all, as I've said. Probably not on my exam, not on any exams, on the bar exam, on the need type question. You're going to have some sort of wacky conflict between federal and state law. You'll get more guidance on this in your bar prep courses. But the way to start thinking about getting into these is to make an argument as to whether there's a conflict at all. Or make an argument on both sides as to whether the law that we're talking about here is procedural or substantive. If you do that, you're probably fine. The conclusion is almost always the House wins, right? The conclusion is almost always the federal law is controlled. Question about that? Keep going.
The only part of this that I think would be confusing right now is the procedural versus substantive.
Okay.
And those are the tests that you talked about the other day that Professor Cross talked about. So do you want us to know those? We might write this.
No, I don't need you to get down to the weeds of what makes something procedural or substantive. How far do you need to get into those weeds for the purpose of bar exam? I don't know. Put it here. I just want you to make sure that's what it's procedural.
When you say make an argument on both sides as to whether the law is procedural or substantive, Are you saying, would the statute say in this way procedural or this way statistical?
Well, okay, let's think back to problem number 2 is a good example, where you have the $20,000 fine fee versus the $100 fine. Is that on the one hand can it be considered substantive because he's such a bar to someone that wants to file in the state court, but no sane human being would ever file in the state court? And does that somehow propel it into the realm of substantive? Ultimately, no. I think the conclusion is just procedural. Yeah, you can flesh out both sides. Okay, this is very rudimentary theory stuff. If you can carve through that, you're well on your way to taking the bar exam and forgetting this and never thinking about it ever again. Okay, plain conclusion. Speaking of which. Also called. As you've got. Anything else? Any other questions on Erie before we leave that planet? Do you want to talk more about it from the outset? Right, now, instinctively, I think your gut at this point, even in your second year of law school, will probably do you some good on these claim preclusion problems. For instance, Hatfield for a bar fight sells the case for $250,000. The settlement results in a judgment, right, on the merits between two parties. 3 years later, McCoy has now been through extensive therapy, realizes just how much more extensive his damages were. And he then turned around and said, look, I didn't realize how bad my damages were in this whole incident. Now I do. Assuming no preclusive language in a settlement agreement, which is not valid. Can he sue Hatfield for intentional infliction of emotional distress? 3 years later. What'd your gut tell you? What was your mother saying? No. No. You had your shot. You had your shot. You don't get to do it. What happens in the Rogers case? Walk through it, there's no time for anything else. Procedurally, plaintiff files a medical malpractice case. Plaintiff files a medical malpractice case, sues everybody in the world, right? Hospital, radiology, stuff, such stuff like that. Hospital moves to summary judgment early on, granted summary judgment on the merits of malpractice. Yeah. Plaintiff sues with the 2 other entities. I'm sorry, settles with the 2 other entities. Gets a $1.2 million judgment that settles it on appeal for $800,000. Okay. Saying, I'm not really too sure about the evidence that I've got here because the hospital screwed up and lost some of that evidence. Files an action against the hospital during the pendency of the medical malpractice case. This is all still going on. Medical malpractice case is still going on. Plaintiff turns around, sues the hospital for losing the x-rays under something called the x-ray retention act. No such thing as I don't know what it is. Basically saying you got to hold on to my medical records. That case is dismissed without prejudice. Refiles the case, and the trial court dismisses it on res judicata or claim preclusion grounds. The trial court says you already litigated, you already had your chance to litigate this. Now you don't get to do that. Why is this different from the hypothetical that I gave you at the beginning of all this? 5 minutes ago. Why is this different than a Hatfield McCoy hypothetical? Flesh out what you mean by that.
Because the statute said you have to keep it up.
Case 1 is medical malpractice. Maybe there's a statutory component, maybe it's common law. I don't think the material feels same thing. Case number 2 is a statutory act. That should tell you something right there. The X-ray retention. The causes of action are different, but I already told you that McCoy wants to sue Hatfield for intentional infliction of emotional distress. Isn't that a different cause of action? From battery? He settles for battery. When he wants to sue for intentional infliction of emotional distress, why can't he do that? Justin.
I was going to say, the ministry needs to basically set us for evidence of these.
Evidence is part of what this court analyzed, yeah. So there's 2 tests. One is the same evidence test, and the other one is the...
I don't know what you can't file the thing, you can't file, because it's on the same pattern limits.
Yeah. The same, yeah, I heard it, but transactions, right? Same evidence test is one. Same transaction test is actually the big one. Yeah. Most courts use, they want to pay a little more attention to it, a little bit more reliable test. It makes more sense. So we're not going to talk a whole lot about the same evidence test. Same transaction test. Why are those tests not fulfilled here? Well, same transaction test. Those are the same facts on the basis of both case 1 and case 2. Boyd versus Hatfield, you got a bar fight. And at the time that bar fight occurred, right, after the injury was infirmed, McCoy at least could have sued for intentional infliction of emotional distress and battery, arising out of that same event. These are the same events being litigated both times in Rogers. The first time it's a medical malpractice, it's the death of the plaintiff's wife. The second time, it's the loss of her x-rays, which happens after she died. Okay? It's not the same facts, not the same transaction. You wouldn't even use the same evidence to prove it. Those X-ray retention act claims could not have been filed contemporaneously with the medical malpractice act. So no, probably not same facts. Same parties, yes. Was there a judgment on the merits in the first case? Yes. Okay. Motion for summary judgment was granted to the hospital, but on a different cause of action. Yeah. Cool.
Not be accurate to say it's the same conduct.
You could make that argument. That's ultimately the argument that was rejected by the appellate court. That's how you analyze this, right? Is there, are we talking about the same facts? Litigated between the same parties? Was there a judgment on the merits? Now, as you might expect, that is more complicated than it sounds. We'll talk more about same parties later on. But just because they're the same named parties, or just because they're not the same named parties, doesn't necessarily mean they're not the same parties for purposes of this test. Okay? Think about think about McCoy versus Hatfield. McCoy sues Hatfield for battery, gets a judgment, and then later discovers, oh wait, he was on the clock for Federal Express. At the time he smashed the beer bottle over my head.